Yes, good afternoon, Your Honors.
Good afternoon, sir. Mr. Kalaya, you're representing the appellant.
Yes, Your Honor, may it please the court. My name is Timothy A. Kalaya from the law firm of Stumphauser, Fosslid, Sloman, Ross, and Kalaya. I represent the appellants in this case, and for ease of reference, I'll refer to them collectively as the Ewings. I'd like to reserve 2 minutes for rebuttal.
You got it, sir. Go ahead, sir.
Your Honors, the Ewings purchased a home from the appellee, John Cassidy, and prior to closing, the Ewings received a home inspection report that identified certain defects. After closing, the Ewings learned of other defects that they did not discover prior to closing and which were not identified in that inspection report. Worse yet, the evidence in this case shows that Cassidy, the seller, as well as his real estate broker and agent, knew about but intentionally concealed many of these defects. Now, the core issue in this appeal is whether the Ewings are barred from pursuing claims relating to the undisclosed defects merely because they learned of certain other defects in the home prior to closing. The answer is no. The Ewings are not barred from pursuing these claims.
Could you let's start at square one. Could you explain to us what you believe the standard should be for the scenario we have here? There were certain things disclosed. Well, maybe lay it out. I mean, for each of your claims, what the standard should be. You know, some of your claims are fraud-based, some of your claims are not. What the Johnson versus excuse me, you tell me. You know what I'm talking.
Yes, Your Honor. So Judge Atkinson, I think the law
that doesn't apply to every case. That doesn't apply in commercial. Sometimes there's exceptions to it that apply only in commercial settings. On the other side is going to have the opportunity to do the same thing. What's the standard?
Absolutely, Judge Atkinson. So 37 years ago, the Florida Supreme Court ruled in Johnson versus Davis that a seller of a home who has knowledge of latent defects.
I've read. We read the phrase. Just what's the standard?
The standard of review or the standard of what?
It's the in which of your claims does Johnson versus Davis apply? And in which of the claims does it not apply? And what is this? What is the takeaway from Johnson versus Davis, and has it been amended by further courts?
Sure, absolutely. So the claims at issue that were resolved on summary judgment are count 2 for misrepresentation and non-disclosure. That is a Johnson versus Davis claim. Count 3 is a fraudulent misrepresentation claim. We think that involves a similar standard. Now, obviously, there's materiality and reliance, but they are based on a failure to disclose facts relating to defects in a home. So similar standards will apply. Count 4 is negligent misrepresentation. And then count 5 is a Johnson versus Davis claim versus the broker and agent. And count 6 is a negligent misrepresentation claim. So the standard really does overlap. And, you know, as the court has acknowledged, the Supreme Court in Johnson versus Davis says that a seller has a duty to disclose latent defects that materially affect the value of the home. And both parties have cited to various cases that have interpreted and expanded this case law over the years. The courts have made clear that the level of diligence required by a buyer is different in cases involving misrepresentations or fraud. So this is a case, Your Honor, where we have allegations of misrepresentations and fraud. And last year, the 4th DCA, interpreting Johnson versus Davis and the other cases the parties cite in their briefs, concluded the following. When a defect, even when a defect can probably be discovered through the exercise of diligent attention, the requisite level of diligent attention is of less importance in claims involving misrepresentations, especially those involving fraud. That's the Lorber case from the 4th DCA. And in that case, the 4th District Court of Appeal explained that even when there are clearly observable defects that may have put a buyer on notice of an issue, the seller's misrepresentations about that issue are sufficient to establish a claim. So with that context, I'd like to just walk the court through a few examples of the types of defects.
While you're on there talking about that, I'd like to, let's focus on 5 and 6 first, the broker case. The agent knew that day when they brought it up that there's probably not 300 feet here. That was a mistake. They had the opportunity to get a survey, did they not?
So that is a disputed issue of fact. What
Well, no. I'm asking you.
Oh,
If this was important to them, they could have bought a survey, right? There was no obligation on the seller to provide the survey, even though you all asked and he said, I think I might have one. There's no obligation for them to provide the survey, correct?
I don't know of a standard under Florida law where a seller needs to provide a
I'm
survey.
looking at the contract. There was not a provision in the contract requiring the seller to provide that proof of the 300 feet, correct?
But that's correct, Your Honor. But I think where this turns to is we need to look back at the Florida Supreme Court case of Bessett versus Bassett. And that case is very similar to this one here. In that case,
Does that case apply outside of a commercial context?
Your Honor, it has been interpreted in other cases. It talks generally about the standard. Now, the standard is more stringent in a residential context. So in a residential context, obviously, the caveat emptor.
That commercial versus residential distinction is cutting your way, you're saying, and I'll just go on.
Exactly. So in the Bessett case, the sellers misrepresented the size of the property and said it was approximately 5.5 acres. Now, it was actually 1.5 acres. Like the appellees here, the sellers argue that the property could have been determined to be less than what it was available to be or what was represented by the sellers. And that's the same here. If the sellers if the buyers in the Bessett case had performed a survey or looked at various property records, then absolutely they put it.
Can I clear something up? I mean, talking about the level of diligence, concealment, they didn't even have to be diligent. Weren't they provided something right before closing that apprised them of the fact that it was a lot less than 300 feet?
Well, that's another interesting issue, Judge Atkinson, and that was an issue that certainly we raised on reconsideration. The Ewings
on reconsideration, who cares? I mean, I'm sorry to be so pointed about it. Who cares about what the supposedly fraudulent issue that was on reconsideration? Tell me why the trial court, anybody, the finder of fact should care.
So on this issue, on whether they learned the morning of the closing, there's a disputed issue of fact.
When I say who cares, I mean your late filed supposedly fraudulent eureka moment about this survey.
Right. So the Ewings had been repeatedly asking for the survey, and it was only the morning of the closing that the broker and agent finally delivered that to Mr. Ewing.
But to go back to my point, if this was so important to them that they needed 300 feet so they could subdivide or market it for all of that, they could have gotten a survey under the contract at any point up to closing. And even when one's provided to them and they look at it, regardless of whether it was fraudulent, they made a decision seeing it. I mean, I know your claim is, oh, they've changed something on it. It was the dates that you were talking about later. But
Judge
at that point, they could have not closed if it appeared that they had not got confirmation that there's 300 versus 100 feet of frontage.
Judge Stargell, that was the morning of closing. The sellers refused to extend the closing date. So under the facts, there's a dispute about whether the Ewings relied upon this, could have reasonably relied upon it, what their knowledge was. Those are disputed issues of fact that should be resolved at a trial where the court weighs evidence.
When did they learn about closing?
They knew the closing date, obviously, when they signed the contract.
So if a week, 2 weeks before, they don't have a survey from the seller, they could have called and got a survey, correct?
They could have, and ultimately they obtained a survey on the morning of the closing, which turns out to be a fraud. Now this goes back to the standard investment.
Well, we don't know that you're making a claim after the fact that it was a fraud. This is not something a court or anyone has found. You're making that as an assertion.
That was
my point. Is you want us to rule against the seller because they did a favor and said, yeah, I think I've got a survey. I'll provide it to you.
Well,
and they provided it to you, and your client didn't stop the sale and didn't get their own survey. So why should we, as to the broker, find that that's a misrepresentation or a fraud when they admitted the listing had something incorrect and you should go check it out?
Well, and it does go back to that. So the Bessett case says a person guilty of fraud should not be permitted to use the law as his shield. nor should the law encourage negligence, which is your concern, Judge Atkinson and Judge Stargel. However, and the court continues, when the choice is between the two, fraud and negligence, negligence is less objectionable than fraud. Though one should not be inattentive to one's business affairs, the law should not permit an inattentive person to suffer loss at the hand of a misrepresentative.
Okay, so fraud requires something more than misrepresentation, and the supposedly gotcha eureka discovery after the fact was that the date was wrong. So doesn't fraud require reliance? In other words, if you have to say, we on the eve of trial, on the eve of closing, what was provided to the purchaser was a document that on its face reduced the waterfront property length by 2/3, and you're saying your client relied on that to go to closing. That's backwards. It's backwards, isn't it?
Right, Your Honor. It's not on the content of the survey. And there's been nobody has assessed that survey. Nobody's looked at the survey to see if there are
just walk me through the fraud. You have to say there was a misrepresentation and it induced us to go to closing because we relied on it. Hey, now that you've told us that that of something that reduces the value of the property we're about to buy, I'm more inclined to go to closing.
So
does that make sense?
Your Honor, the broker and agent admit that they knew prior to closing that the water frontage was less than 300 feet, and they admit that their listing included false information. It said,
and they told the broker or the I don't know if he's a broker or just an agent for the buyers
absolutely
right up front. So you were on notice.
Well,
that was just fraud.
A realtor is on notice, but not the Ewings.
Oh, okay. So I see. You think that information that goes to the agent that's represented, there's a problem with, I guess, my understanding of the agency theory. So walk me through that.
So it's a question of fact. So the argument is that they told the Ewings agent, the realtor, about this discrepancy, and therefore this knowledge should be imputed to the Ewings through an agency theory. But the Ewings,
so the agent, they discussed that there's 300 versus 100. So we need to get their survey and we need to keep demanding the survey. But he never told them that they admitted that there's less than 300.
Exactly. So it's a question.
So why aren't you suing your agent?
Well, frankly, that was a claim that was in a motion for leave to amend, which is also on appeal. We wanted to sue the agent because we believe that he didn't do his duty to the extent he was told by the sellers.
Before we get to the leave to amend, could you answer my question? Because I mean, you can please be frank and tell me I'm missing something. But if you're invoking all these principles that have to do with fraud with regard to the 300 feet, and fraud requires not only a misrepresentation and not only intentional misrepresentation, but reliance upon it to induce them to go to closing. But what was supposedly fraudulent was something that actually would have actually decreased their motivation to go to closing. Could you please square that circle for me?
So on this particular issue, on the water frontage, the fraudulent statement was the property listing. There's a forgery potentially related to
I know, but I thought the smoking gun was that the survey that was provided was itself fraudulent because of some sort of ancillary discrepancy.
So that is a fact, that's a consideration related to this claim. But the main thrust of it is that the property listing said that the property was 300 feet of water frontage. That was what was always represented to the buyers. That's what they believed to be the case. And there's a question of fact about whether they were told by the agent, whether they were told by their own realtor, that it was something other than that. And the Ewings have sworn the evidence in front of the trial court was a disputed issue of fact.
But before we move on to the other issues, which we probably should, let's back up for a second and get back out of the fraud milieu and talk about the Johnson versus Davis and say, how does their walking the property and all this evidence, that undisputed evidence that they were, skeptical and they found it dubious that this was 300 feet, not satisfy the Johnson versus Davis in favor of the seller?
Well, so that is one issue. Obviously, we're talking about the water frontage. There were a number of defects that were raised by.
All right, let's go to these other defects. Okay, fine, good.
Sure. So, for example, let's talk about the electrical. As both parties pointed out in their briefs, the Ewings learned from the inspection report of two minor electrical issues. First, There was an outdoor receptacle that didn't have a weatherproof cover. That's a simple fix. You can buy a new cover from Home Depot for $5. And the second issue was a double tapped breaker. Basically what that is a breaker in a panel that has two wires connected to one breaker. Again, a relatively simple fix. Those are defects. Those were disclosed absolutely. And therefore the Ewings can't pursue claims based on those two issues. But those were the only two minor electrical issues they learned about in the inspection report.
On that, do you also need, for Johnson versus Davis, do you also need to, let's say take for the sake of argument that that the problems themselves were drastically worse than any reasonable buyer would have been suspicious of by virtue of the report. Don't you need to have some evidence that the seller knew as well? I mean,
Absolutely.
this is a little different than painting over the mold.
Right.
You know, is Mr. Cassidy, is he an electrician by avocation or something? How do you know?
On the electrical issue, the defect that the Ewing sued for was that when they opened the walls, the wires looked like spaghetti. They were sliced with wire nuts and unprotected.
Yeah, how does the seller know that?
So when the Ewings did their diligence and were doing the repairs, they saw labels on the wiring that showed it was installed during the time when Mr. Cassidy owned the house. And there were no permits pulled. This was unpermitted electrical work. And therefore, there's at least a suggestion that Mr. Cassidy, Dr. Cassidy, knew about these issues, was on notice of these issues, and failed to disclose them. And under the circumstances, you know, essentially what the appellees are arguing is that the court should apply a standard that because there's two issues that were identified, two minor issues, the Ewing should have upended the property, torn down every wall to inspect every electrical wire in the home because of those two minor issues. That's not the law. That's not what buyers are required to do. Buyers are certainly precluded from seeking recovery for any defects they were aware of or reasonably could have ascertained prior to closing.
But when a buyer is told, get a plumbing contractor, get an electrical contractor, get an engineering contractor, get somebody to check the foundation, and they don't do it, who's at fault for that?
It depends on who the trier of fact determines. I mean,
No, the facts are clear. Your client didn't do it.
well, Your Honor, Judge Sleep,
Every report said, get somebody who knows how to do it. I'm just an inspector. I'm not an engineer. I'm not a plumber. I'm not an electrician.
but there
your
were other
clients
issues
didn't
that were clearly known by the seller, and they concealed and failed to disclose. So, for example, another claim involved flooding on the front property. In the seller's disclosure, Cassidy specifically represented that he wasn't aware of any flooding issues ever at the property. Now, after closing, there was a moderate rainstorm, and that resulted in standing water in the front yard and driveway of a depth between 2 and 3 feet that did not subside for several days. This was a significant issue. Once they learned about these flooding issues, the Ewings investigated and learned that Cassidy had in fact work performed in that area that involved installing a private drain that made the county storm drain inoperable, which was the cause of this flooding. And Cassidy says in his brief, the Ewings should have learned about this or potentially known about it because, number one, the property is near sea level, and number two, there was some minor settlement of brick pavers in the driveway.
And also there was a sump pump, right?
But that's a different issue. That was inside the house. This is flooding in the front yard and driveway. There's a million
Generally,
factual
I mean,
issues.
so that's even lower than what would be in the house. So if there's a sump pump was higher, doesn't that tell you, okay, well, there could be the possibility. I mean, this is a coastal property, correct?
It is, but
So to assume that you're not ever going to have any flooding or water in your front yard, once again, is that not incumbent on the buyer to find out from whoever, the neighbors, whomever, and see, you know, is there ever water in my driveway? Is there ever water I need to go through? Or to ask more questions of the seller?
So the buyer is certainly free to ask any questions, but Johnson versus Davis and its progeny says that the seller, if it has knowledge of issues, if it has knowledge of these defects, has a duty to disclose. And in a situation where the seller makes a misrepresentation, here, Mr. Cassidy, Dr. Cassidy made a representation that he wasn't aware of any flooding issues.
So let me ask, so that representation there, that's evidence in the summary judgment evidence. He said, I am not aware. So in other words, taken at face value, in my experience, it never flooded. So there's a couple, so we're here on summary judgment, issues of law, it's a de novo review. What inferences can be drawn either way? I am not aware yet. I have a sump pump in the mother-in-law suite, which, as Judge Stargell mentioned, and we don't even have to take judicial notice that there are not many basements in Florida, probably not on an island, is above where the flooding was. So either under two scenarios, one, which is, Johnson, which is, hey, shouldn't you have known? But another one is again, going back to fraud, which is, did you justifiably rely on this seller saying, I don't remember ever flooding? And you're like, oh, well, there's a sump pump. Why would you have a sump pump then? I mean, under either standard, why should the plaintiff be able to recover here?
Sure.
Before you answer, you're at 20, but we asked you a lot of questions. So I'll give you 2 additional minutes. Do you want them for rebuttal, or you just want to use them now?
So, and I've gotten through about 2% of my argument, obviously, the court's questions.
Sorry.
That's, of course, I understand what the court is concerned about. And let me just go back to the 4th District Court of Appeal opinion in Lorber of last year. In that case, the 4th District Court of Appeal very clearly says a seller's false representation about a defect is sufficient to establish a fraud or misrepresentation claim, notwithstanding other facts suggesting that the defect was observable. What the Ewings could have observed, what they could have investigated and determined, is irrelevant when there's fraud and misrepresentation. And ultimately, at best or at worst, it's a question of fact that cannot be resolved on summary judgment. All of these claims, when we're talking about the different cases that we've spoken about, Johnson versus Davis, that's a case that went to trial. The Pressman case that the appellees cite to went to trial. Nelson versus Wiggs went to trial. The Schottenstein Holmes case, the Florida Supreme Court said that should have gone to trial. There were numerous disputed issues. The trial court committed error because it resolved every single inference and every single disputed fact in favor of the appellees. Your Honors, I will reserve a remaining argument and refer back to, obviously, our briefs on the remaining issues that we didn't get to discuss.
All right. Thank you, sir. Good afternoon, counsel. I see 2 of you. Would you like to split your time?
Yes, Your Honor.
What would you like to do that?
Determined is that I'm going to take the first 15 minutes on behalf of Dr. Cassidy, and then Mr. Dudek is going to take the remaining 5 minutes on behalf of Michael Saunders and Company and the individual agent.
All right, sir. You may proceed, Mr. Walls.
All right, thank you, Your Honor. I wanted to pick up on just 2 concepts before I get into my argument. The other argument, 2 concepts that came up during counsel's prior argument just now. The first one, from a question from Judge Atkinson, I think what we're going to see here, particularly from the inspection report, is that these buyers didn't have to be diligent. They were told of these defects in the inspection report. So that's one concept. They didn't have to be diligent or search for things. They were told of these defects. And the second concept that I think is important, particularly for the electrical as it came up, and I think it came up on another one as well, is that the standard for Johnson versus Davis is that the seller had to have actual knowledge of the defect. And I think as Your Honor was asking questions about the electrical, it became very clear that the what they had is at least a suggestion, only a suggestion, that the work was done while Dr. Cassidy owned the house. And the facts that are pretty clearly in the record is Dr. Cassidy didn't even live there for the bulk of the time. It was a rental property, and a suggestion that work was done while he owned the house falls extremely short, entirely short of the actual knowledge standard for Johnson versus Davis. So they just didn't establish actual knowledge on behalf of Dr. Cassidy with regard to the additional electrical problems that were inside the wall. I wanted to mention those 2.
On that issue, though, could you please apply it to the roof? Yeah. Was there not evidence that Mr. Cassidy was aware of something that was not ascertainable by the buyers?
Well, there might have been, but that's the roof is, I think, the clearest example. Actually, I think there were about 3 totally clear examples of what they were told in the inspection report gives them all the knowledge they need. The roof,
Okay, tell me, walk me through that. What is that? You said,
absolutely.
oh, it's near the end of its use.
Well, they were told it was.
Does that say, well, when I move in, it's gonna just, everything's gonna come down on my face?
Well, of course, no one knows what's going to happen with that, but I will address exactly what Your Honor asked, which is that the Maceo report, which is the inspection report for the Ewings, in the context of the contract, that they had an inspection clause in the contract that allowed them to get out of the contract if they did an inspection and found in their sole discretion any problem that caused them concern. So the Ewings could get out of the contract upon finding any problems. The Maceo inspection report has a kind of a code denoting some things as defective, some things as marginal, and some as lesser. I'm obviously going to be talking about defective and marginal here. Defective is defined as needs immediate repair or replacement. Needs immediate repair or replacement. Second phrase, it is unable to perform its intended function. And the roof is defined in the Maceo report as being defective. On top of that, that's just the report itself. On top of that, we talked a little bit about the agency issue. We absolutely contend that the Ewings have imputed knowledge through their agent Williams. Williams knew that they needed a new roof. There was open knowledge between the agents. It was discussed. It was absolutely clear that they needed a new roof. If the roof is defective and it needs immediate repair or replacement, they've been told that they've got a defective roof.
Okay, so needing a new roof, but what can mean many things. It could mean the shingles, and is it perceivable that there is a fact issue as to of exactly what that put the buyer on notice when there was potential for something much more than a new roof? I mean, does a new roof usually include all the support structure for the roof, or just the shingles?
Well, I contend that a new roof is everything that goes into a roof. Shingles.
Based on what?
Well, for one thing, the inspection.
So you contend, but what does the
Yeah.
summary judgment evidence indicate that being on notice that you need a new roof means?
Well, the
to a
summary
reasonable
judgment evidence was that their agent knew that they needed a new roof, that the inspection report told them they needed that their roof is defective, and at the end of its useful life and does not perform its intended function. So what I take that to mean is that anything that's wrong with the roof, they need to fix it. They need to fix it, and it actually says immediate repair or replacement in the inspection report. To my recollection, the summary judgment evidence did not parse between shingles versus other. They made that argument, but the summary judgment evidence did not parse between the two. Clearly, when they arrived on the property the very first day, the shingles were surrounded around them on the ground, and that remained that way. It was perceived as being literally too dangerous for someone else to get on top of the roof. But they were told it was a defective roof that needed immediate repair or replacement. And I think that's where the judge landed, is that if you know you have a defect, they claim their allegation is they had a defective roof, and the inspection report told them they had a defective roof. And that's the same thing with the plumbing. The plumbing report, there were two inspection reports that bore on the plumbing. I'll start with the Maceo report. The Maceo report told them they had.
Before you go to that, I have a question on the roof, but just to finish up Judge Atkinson's question. So sure, you've got shingles or clay tiles or whatever you end up having on a roof structure, and then there's the underlayment, and then under that you're going to have some sort of a foundation. There was something in one of these that said it was difficult, I guess, to get up into certain areas of it, but they were on notice that, I guess your position, they're on notice that they need to get into the attic, they need to get up and observe whatever it is to see the extent of the roof damage.
Our position certainly is that they're on, just using the words of the inspection report, on notice that they have to immediately repair or replace their roof.
So
and-
whether that involves more than what's there, or, you know, just the shingles, whatever it is,
And-
wherever
and-
the water
yeah.
damage has gone down to, that's their responsibility because they're aware that there's a roof problem.
Absolutely, and putting it in context of the contract, and it's paragraph 12 of the contract, you know, once they're aware from that inspection report that they have a defective roof that needs immediate repair or replacement, they have a choice. And actually, there are probably three choices they might have. They can get out of the contract immediately. They can go to the seller and say, hey, I've just been told I have a defective roof, you fix it and then I'll buy your house. Or they can close under this as-is contract, knowing that they have a defective roof. Knowing that they have a defective roof.
I'll add a fourth. They could renegotiate the price and
Exactly. Well, I was kind of rolling that into that first option I gave, where they can go to the seller and say, you pay for it. But yes, they can renegotiate the price. But they elected the option of knowing they have a defective roof that needs immediate repair or replacement. They chose, let's go forward and close on this as-is contract. And they made that same choice on all of these other defects. The plumbing, parts of the plumbing were defective. The vent pipes, the water lines were marginal. The drain pipes were defective. There were active leaks in the vent pipes. There's an active leak up in the attic from the vent pipe. There's an active drain pipe leak down into the non-conforming mother-in-law suite. With those defects, they likewise chose, with knowledge of those defects, to go forward and close. And then the pool deck is another egregious example. The pool deck, they even had an escrow agreement because the buyers knew they were going to go work on the pool deck. The escrow agreement focused on the permitting, maybe back permitting costs for the work they're going to do. But the inspection report on the pool deck said it's not safe. Don't go on there without an inspection from an engineer. And it specifically said that is not properly supported. And as I read their allegations now, what they're saying is, oh, you didn't tell us it wasn't properly supported. Well, the inspection report told you that. You knew it was not properly supported, and then you made that choice that I talked about. You made that choice to close on the deal, knowing that you have a defective pool deck, defective plumbing, defective roof, leaks in the area of the master bedroom, both in the closet and in the attic above the master bedroom. You knew about those, and on that one, there was a testimony from Mr. Ewing's deposition that maybe he should have done something about that. Maybe he should have asked about that leak. He didn't. Instead, he closed, knowing he has a leak, and then complains about the consequences of the leak he knew about. You know, so I heard Mr. Kalaya talk about concealment, but all of these issues that they've alleged with concealment, we talked briefly about electrical. It was in the walls, and there's no proof of actual knowledge on the part of Dr. Cassidy. The plumbing, the roof, the concealment doesn't work because they were told and have actual knowledge. The Bassett case that I think that they referred to, you can rely on a truth of a representation unless you know the representation to be false or it is obvious. And you know, if they were told, hey, you have no problem whatsoever with the roof, and then you get your inspection report that says you have a defective roof that's at the end of its useful life, no longer serves its intended purpose, you know it to be false and it's obvious.
Real quick, that what I'm describing perhaps improperly as an exception to, the right to rely. Is that applicable outside of commercial real estate?
Outside of commercial?
Yeah, the Bassett case that was.
My understanding, my understanding is that as I was approaching it, that theory applied that yes, you have a right to rely unless it's known to be false. That's what I understood the law to be. But our point is that on these particular defects that they are complaining of, they knew them to be false. I mean, for example,
you're talking about that a recipient may rely on the truth of representation, even though its falsity could have been ascertained had he made an investigation. And I was perhaps focusing on that. You're focusing on unless he knows representation to be false or its falsity is obvious. All right.
And that's the one-eyed horse.
Right. Okay. So if it's not a one-eyed horse, but maybe the horse has macular degeneration, then the other clause might be operative, which is even though its falsity could have been ascertained had he made an investigation. That I invite anybody to correct me if I'm wrong, because I might be. It doesn't apply outside the commercial setting, I don't think. In other words, if there's, I don't know if it's a fulcrum point or it's a gray area or a slack tide or whatever between the horse has, one eye or the horse, has myopia, then if it's just, hey, well, you could have ascertained the falsity based on some diligent investigation. I'm not sure that applies outside a commercial real estate transaction. Whereas you're saying, well, even if it's residential, if you know it's false, you can't rely on it. That just sounds like fraud. I mean, that means that's just no reliance. It's not even something you need.
Well, it's not justifiable. It falls in the same.
It's not justifiable reliance. It's not even saying anything unique. Hey, well, obviously you have to justifiably rely on it. So, but isn't the operative phrase in Bassett, even though its falsity could have been ascertained had he made an investigation? Unless, of course, you're correct, which is that, it was obvious that Mr. Cassidy was lying, but where is that obviousness in the record?
Well, the obviousness starting point is in the Maceo inspection report. I mean, first of all, I don't concede that Dr. Cassidy was lying.
I didn't think you would.
but in the context of all of these defects, we've talked about the roof, we've talked about the plumbing, we've talked about the pool deck. The defects they're complaining about are in the inspection report as defects, as these items are defective and they need immediate repair or replacement. And for example, on the plumbing, what they complained about as a defect in their complaint is that the plumbing was unpermitted. Well, the inspection report tells them that the plumbing was unpermitted. So they knew it prior to closing.
You're at 15 minutes, but I'll let you finish answering the question.
Okay, so the point is that they knew what they needed to know affirmatively from the inspection report and from Williams, imputed knowledge through Williams, had affirmative knowledge of these things, that even if there's some allegation that they were misled in some way by Dr. Cassidy, they had affirmative knowledge that these things were defective before they closed at a time where they had an option under paragraph 12 of the contract to simply walk away. And they chose instead, with that knowledge, to close. So in closing myself, Your Honors, we're asking that you affirm the final judgment as it relates to Dr. Cassidy. Thank you.
Thank you. Mr. Dudek.
Good afternoon. As Mr. Wallace mentioned, my name is Kyle Dudek. I represent two of the appellees in this case, Ryan Skarpowski and Michael Saunders and Company, and they were the real estate agent and broker for Dr. Cassidy. Before jumping in, I want to take a second to reorient things. I know we've been discussing a lot of defects in the roofing, in the pipe, in the pool deck, but the claims against my clients are limited. The only alleged misrepresentations in the complaint as to the broker defendants, who I'll refer to my clients as, were two. And first is that the property contained 300 feet or less of water frontage. And second was the ground floor of the house could not be used as a living space. Those were the only two misrepresentations that were made allegedly made by my clients. Now, the issue about the lower floor being livable space, that's been abandoned, that hasn't been brought up. The only issue that was presented to the trial court for summary judgment and is here today is about the water frontage. And right at the outset, as opposing counsel noted, there was a misrepresentation. the MLS listing from my client said that the property had 300 foot of water frontage, and that was incorrect. The actual water footage is closer to 100 feet. I believe it's 110 or 104. But the problem with the plaintiff's claim about that misrepresentation is the reliance element, which Judge Atkinson, you talked about, is that even if you have a misrepresentation, you still have to prove that you reasonably relied on that misrepresentation in entering the contract. The problem the plaintiffs have in this case are the facts are undisputed that the day after the Ewings went out to the property, there was a call between my clients and their real estate agent, Ray Williams. And during that call, it was told to Mr. Williams, there is not 300 feet there. There is less. It's closer to 100. And you can see in the testimony of Ray Williams, he says that they had that call. He says that he was told that it was less than 300 feet. He also says that on the date that they inspected it, he paced it out and said it was less than 300 feet in front of the Ewings. And there's an email correspondence from Mr. Williams to my clients saying, we have concerns about the water frontage. So this is not a case where there was a misrepresentation about the MLS listing that carried all the way forward to closing, and they relied on it believing they had 300 feet. It was told by my clients to Mr. Williams that it had less than 300. So they cannot, under the facts, say that they relied on that initial MLS listing any longer. Now, there's been some discussion in the reply brief that the knowledge to Mr. Williams shouldn't be transferred to the Ewings because he was acting in his own self-interest. And in those circumstances, the knowledge isn't transferable. Well, the problem with that argument is it was never raised in opposition to summary judgment. It was never raised on the motion for reconsideration, and it was never raised in their initial brief. What they've done is they've just taken that issue, raised it for the first time in the reply brief, so I would say it's waived. But the second part, the case they rely upon for that statement is not a Johnson v. Davis case. It's in the context of a different transaction. And in a Johnson v. Davis case, you're dealing with a very specific relationship, and that's between four parties. You have a buyer, a seller, and then the real estate agents for each. And the obligations, as I'm sure all the panel knows from having probably bought a house in their own history, is that the communications are usually between the agents. The seller talks to their agent and the buyer talks to their agent, and that's how things are disclosed. And then the agents talk to each other. There's no direct conversations between each agent and the other side. And so by disclosing it to Mr. Williams, they did what they needed to do to correct that misstatement in the MLS listing. There was nothing more that they could have done. Now, even setting aside the issue of what Mr. Williams knew and whether it can be transferable, you fast forward to the day of closing. And the day of closing, they receive a document, the survey. And the survey lists the water frontage at less than 300 feet. So even if you can say that Mr. Williams's knowledge can't be imputed, they had, prior to closing, in their hands a document that said it's less than 300 feet. Now, they've said that the survey was a forgery, that there's an issue with it. That's all fine, because the problem is that it put them on notice at that point that there was an issue with the water frontage. And so they shouldn't, having that survey in their hand that shows something different than the MLS listing, means they can't rely on that statement of the 300 feet before. And setting all that aside, the only thing that they've shown about the survey that was inaccurate was some date that apparently exists on there. So, and the end of the day,
I have a question for you just in general, because I know your time's, and both of you can answer this. From the standpoint of the contract itself, you're talking about at the end of it, but at the very beginning, it's an as-is contract as opposed to the standard contract. What difference, if any, do you say that makes in this transaction?
Well, for my clients, I don't believe it makes much, if any, in the sense of we've got Johnson v. Davis claims on my end to deal with an affirmative misrepresentation made. It's not a failure to inspect on their end. So I believe that might apply more to Mr. Wallace's.
Right, I agree. I wanted to see and give you both a chance to answer that
Sure, and I'll certainly leave a
record.
little bit of time at the end for Mr. Wallace to chime in there. So,
Mr. Wallace has used his time. You've got 30 seconds.
okay, so at the end of the day, the court was faced with those facts, that it was disclosed to Mr. Williams and that they had a survey showing that it wasn't 300 feet. And the court made the decision that the only decision that can be made from the record is that there could be no justifiable reliance on those facts. And so with that being said, I believe I'm out of time. And unless the panel has any additional questions.
I don't think so. Thank you, sir. Mr. Kalai, I'll give you a minute and a half.
Thank you, Judge Sleet. So Judge Stargell, almost every contract in Florida for residential sales is an as-is contract. That's a standard contract that's used throughout the state, and it doesn't displace Johnson versus Davis. I want to note briefly that the parties are almost talking past each other. The appellees are saying that the buyers knew about certain defects, so therefore, according to the appellees, the buyers can't recover for any defects, no matter whether the appellees knew about and actually conceal these facts from the Ewings. That is not the law. That's not permitted under the standard. So, for example, on the roofing, and Judge Atkinson was asking about this. In the seller's disclosure, Cassidy made the following statement: "Has the roof ever leaked since you own the property?" He answered no, and beyond that, he went forward and wrote in his own handwriting, "I bought the house 9 to 10 years ago and no roof problems." That's what he said. But during discovery, the Ewings obtained emails, and this has been submitted on the record, that Cassidy was told about additional necessary repairs, and that if this work wasn't performed, quote, "the roof is just going to leak somewhere else." Cassidy responded to that email and said there was, quote, "no need to get estimates on the roof, as I won't be doing major work on it." So that the evidence is clear in this case, or the record is clear, that there's facts establishing that Cassidy knew about these defects, made specific misrepresentations, and at a minimum, there's a disputed issue of fact for trial about to what extent the Ewings are able to pursue these claims. I want to talk very briefly about the broker and agent. They say that there's two
Very
issues.
briefly.
They mentioned that there's two
10
issues.
seconds.
Well, Your Honor, with 10 seconds, I will ask the court to please reverse the order on the trial court. The amendment was denied improperly. The summary judgment should have gone to a jury, and the court improperly refused to allow rehearing or reconsideration. On those bases, we would ask that you reverse.
Thank you very much. Well argued. All of you have a nice day. Good to see you.